Hey everybody, Steve Schwinn here. So the Supreme Court issued a major decision this week that said that the president isn't categorically absolutely immune from a state grand jury subpoena that seeks the president's personal financial records. The case is called Trump versus Vance. Let's take a look. So let's start with a little background. A state grand jury issued a subpoena to President Trump's accounting firm called Mazars for President Trump's personal financial records as part of a criminal investigation. President Trump then sued the state prosecutor, Vance, in order to stop the subpoena. And in doing so, President Trump made a sweeping, breathtaking claim. What President Trump said is the president, by virtue of his position as head of the Article 2 branch of the federal government, the president is absolutely categorically immune from all state criminal processes. The Supreme Court flatly rejected this sweeping claim. What the court said is that the president has long been subject to subpoenas in federal criminal cases, and there really isn't anything different about the president being subject to a subpoena in a state criminal case. What the court said in particular is that the president's reasons for claiming absolute immunity simply don't hold up. So, for example, the court said that the president's claim that a state grand jury subpoena would distract the president from the president's duties, well, that was no different than the president being distracted from a federal criminal subpoena, and the president has long been subject to federal criminal subpoenas. As to the president's claim that a state grand jury subpoena to the president would be stigmatizing to the president, what the court said is there's nothing stigmatizing about complying with a state grand jury subpoena, just like anybody else would comply with a state grand jury subpoena. And finally, as to the president's claim that there are some 2,000 state prosecutors out there who could use the subpoena power to harass the president, well, what the court said is, look, there are already built-in protections against that kind of misuse of the subpoena power. And to the extent that a particular prosecutor misuses the subpoena power, well, the president is free to challenge that particular subpoena in state or federal court. And that's really the upshot in this case. What the court said is, look, we're going to deny the president's absolute categorical claim of immunity from the subpoena, but if the president would like to challenge this particular subpoena under state law or federal constitutional law as an impermissible intrusion into his Article 2 powers and thus violating the Supremacy Clause, for example, well, the president can lodge those claims. But the court rejected the president's absolute categorical claim of absolute immunity against a state grand jury subpoena. Importantly, despite the two dissents in the case, all 9 justices agreed that the president does not enjoy this absolute categorical immunity from state grand jury subpoenas. So what does all this mean? Well, first and foremost, it means that the president does not enjoy absolute categorical immunity from state criminal procedures. What it means for this particular case is that President Trump now will have another opportunity to challenge this particular subpoena as violating state law, for example, as being unduly burdensome, or violating federal constitutional law. So that means that the state grand jury is unlikely to get its hands on President Trump's financial records anytime soon, maybe not even before the election in the fall. And remember, even if the state grand jury does get the materials, the state grand jury proceedings are secret, and so the materials will stay under wraps, at least for now. So now the ball is in President Trump's court again, and he has an opportunity to lodge these additional challenges. We'll keep an eye on what President Trump does and what the courts rule. I hope this has been helpful, and I look forward to seeing you next time.